Let's dive right into this explainer. Today, we're doing something pretty ambitious. We are going to objectively map out 30 years of Pfizer's legal history. And just to be totally clear up front, we aren't looking at rumors, we aren't looking at speculation. Everything we cover today is drawn strictly from official records. We're talking the Department of Justice, the FDA, the Competition and Markets Authority, and the Good Jobs First violation tracker. What you're about to see is a comprehensive, chronological look at the judicial convictions, the criminal fines, and the massive settlements of this pharmaceutical giant and its subsidiaries. To keep this massive timeline organized, we're going to break it down into 5 key eras: early fraud and price fixing, the Warner-Lambert fallout, the 2009 record fine, a wave of international corruption, and finally, modern monopolies and generics. We'll start back in the 1990s and work our way right up to a pending settlement in 2026. Let's get started.
All right, era number 1, early fraud and price fixing, covering the late 90s through the year 2000.
Looking back at the late 90s, we start seeing some really systemic issues take root. In 1996, a $408 million civil settlement came down on Pfizer and 14 other major labs. Why? Because they were coordinating to artificially inflate the prices they charged independent pharmacies, basically squeezing the margins of local everyday businesses. Then, fast forward to 1999, and a Pfizer subsidiary actually pleaded guilty and paid a $20 million criminal fine for participating in a literal international cartel to fix the price of a food preservative called erythrobic acid. We round out the turn of the millennium in the year 2000 with a $50 million settlement with the state of New York. The accusation there was deliberately overcharging Medicaid, a publicly funded program, by intentionally failing to offer the state the exact same discounted prices they were giving to other corporate customers.
Moving on to our second era, the early 2000s. This period is really defined by aggressive marketing tactics and the heavy legal baggage that came with acquiring a company called Warner-Lambert.
First up in 2002, let's look at the blockbuster cholesterol drug Lipitor. Pfizer got hit with a $49 million civil settlement by the DOJ for false advertising and price fraud. The core issue was that they were actively concealing financial discounts that they were offering to private healthcare providers. Doing that allowed the company to completely avoid paying the legal rebates they actually owed back to the state-funded Medicaid program. Now, before we look at the next big case, we absolutely have to talk about a concept called off-label promotion. You might be wondering what exactly that is. Well, it's when a pharmaceutical company markets a drug for a disease or a condition that the FDA has not specifically approved it to treat. Look, doctors can legally prescribe drugs off-label if they think it's the right call for their patient. But pharmaceutical companies, they are strictly forbidden from actively marketing them for those unapproved and, frankly, often untested uses.
Which brings us to the massive 2004 Neurontin case, a textbook example of off-label promotion. Warner-Lambert, which Pfizer acquired back in 2000, pushed their anti-epileptic drug Neurontin for uses the FDA never greenlit. And they weren't just passively hoping doctors would prescribe it. Their sales reps actively targeted medical professionals, heavily pushing the drug as a treatment for bipolar disorder, migraines, and even alcohol withdrawal. Ultimately, the company pleaded guilty, paying a $240 million criminal fine plus $190 million in civil penalties. That is $430 million in total. Okay. We've hit 2009. This is a massive landmark year in this timeline. We are talking about the largest criminal fine in American judicial history at the time. $2.3 billion. I mean, just let that number sink in for a second. This wasn't some minor civil slap on the wrist. This total included $1.19 billion specifically in criminal fines for the actual crime of fraud, alongside $1 billion in civil damages under the False Claims Act.
So what on earth did they do to rack up a $2.3 billion fine? Well, it boils down to public health fraud, bribery, and illegal promotion regarding the anti-inflammatory drug Bextra. They were actually promoting it at non-validated, highly elevated dosages. And here's the kicker. This was happening despite the drug being withdrawn from the market entirely in 2004 due to severe cardiac risks. But it wasn't just Bextra. The settlement also covered the illegal marketing of 3 other drugs: Geodon, Zyvox, and Lyrica. And to drive these sales, Pfizer admitted to paying kickbacks. We're talking funding luxurious travel, golf outings, the whole shebang, directly to doctors to improperly influence them to prescribe these medications to their patients. As we cross into the 2010s, our 4th era begins. Here, the scope goes global, with international corruption and some really severe, concealed drug risks coming to light.
The consequences of past actions definitely continue to ripple forward here. Remember Neurontin from 2004? Yeah, they weren't done with that yet. In 2010, a jury hit them with a RICO conviction, the law usually used to take down organized crime, because they had continued to fraudulently promote Neurontin, which resulted in another $142 million penalty. The very next year, we see a $14.5 million False Claims Act settlement for illegally promoting the incontinence drug Detrol. And then in 2013, the Wyatt subsidiary, which Pfizer bought in 2009, pleaded guilty and paid $491 million for deliberately training its sales force to push doctors to prescribe the immunosuppressant Rapamune totally outside its strictly authorized use for kidney transplants.
We also have to look at a genuinely tragic case that settled in 2011. The company reached a $75 million out-of-court settlement with Kano State in Nigeria. This all stemmed from a 1996 meningitis outbreak where Pfizer tested its experimental antibiotic, Trovan, on 200 children. Official reports state that this medical testing was conducted without the informed consent of the families. It's incredibly devastating. The trial resulted in the deaths of 11 children, and dozens more suffered severe, permanent disabilities. After years and years of intense international litigation, Pfizer ended up paying $35 million into a compensation fund and funding local health projects. Then in 2012, international scrutiny really ramped up. Pfizer ended up paying over $60 million in fines and disgorgement for violating the Foreign Corrupt Practices Act. They officially admitted that their subsidiaries paid bribes to government officials, hospital administrators, and doctors. And the scale of this was massive. It spanned across China, Russia, Italy, Bulgaria, Croatia, Serbia, and Kazakhstan. The whole purpose was straightforward: systematic payoffs offered in exchange for fast-track regulatory approvals and illegally boosting local sales inside state-run hospitals. That exact same year, a huge wave of civil litigation finally wrapped up. Individual settlements totaling right around $1 billion were paid to close more than 6,000 lawsuits. Imagine the sheer scale of that: 6,000 individual cases. These were brought by women who claimed that the hormone replacement therapy drug Prempro caused their breast cancer, and the core of the lawsuit was that the company had knowingly downplayed those severe cancer risks to both patients and prescribing doctors for years. And just a year later, in 2013, they paid out $273 million in civil compensation to settle over 2,000 cases involving the smoking cessation drug Chantix. Here, the lawsuits accuse the company of actively concealing serious psychiatric side effects, alleging that the drug caused suicidal thoughts, homicidal behavior, and profound psychological disorders that patients were just never adequately warned about. All right, that brings us to our final era, leading us from 2016 right up to the present day. We're shifting gears here. The regulatory focus moves slightly away from marketing fraud and more towards structural monopolies, antitrust violations, and really complex pricing manipulation.
Kicking off this era in 2016, the Wyatt subsidiary gets hit again, this time with a massive $784 million civil settlement under the False Claims Act. They were convicted of fraud against the Medicaid program for knowingly depriving public health programs of the bulk price reductions for the drug Protonix. The problem was they were actively offering those exact discounts to private hospitals, which is a direct violation of federal pricing rules. Now, take a look at this number, 2,600%. That is literally the overnight price hike that the UK's National Health Service was slapped with when Pfizer deliberately debranded an anti-epileptic drug called Epineutin. Basically, by stripping the brand name and selling it generically, they found a loophole to temporarily evade strict government price regulations placed specifically on branded medicines. The UK's Competition and Markets Authority stepped in, ruling this as an anti-competitive abuse of their dominant market position. After years of appeals going back and forth, they maintained a record final fine of £84.2 million in 2022.
To make sense of these next couple of modern cases, we need to quickly talk about a strategy called pay for delay. It's exactly what it sounds like, and it's highly controversial. It's a financial agreement where a brand-name pharmaceutical company literally pays off a competing generic drug manufacturer to delay bringing their lower-cost generic version to the market. It's designed to artificially extend a profitable drug's market monopoly, which, as you can guess, ultimately keeps prices super high at the pharmacy counter for everyday patients and health systems. We actually see these exact market manipulation strategies playing out recently. First, in 2018, Pfizer paid a $23.8 million settlement for secretly financing kickbacks through charitable foundations. They essentially used third-party charities to pay the out-of-pocket deductibles of Medicare-insured patients. That completely manipulated the system by illegally incentivizing patients to choose Pfizer's high-cost drugs, Ticlocin and Renvela, over cheaper alternatives. That shifted the massive remaining costs right onto the taxpayer-funded Medicare program. And then, super recently in 2024, a federal court validated a $35 million civil settlement after Pfizer was condemned for utilizing that pay-for-delay strategy we just talked about, this time to block a low-cost generic competitor for its blockbuster drug Lipitor, artificially keeping those pharmacy prices high.
And finally, looking ahead to the immediate future, specifically March 2026, there's a pending $29 million agreement waiting to be validated by a Manhattan court. This involves Pfizer recovering funds that were originally seized by the SEC relating to collateral financial disputes from an old stock market and insider trading fraud perpetrated by hedge funds on shares of its subsidiary, Wyeth. So having mapped out this entire 30-year journey together, seeing the progression from price fixing in the 90s to off-label promotion to that massive 2009 Bextra fraud, the international bribery, and these modern pay-for-delay tactics, I'm going to leave you with this to consider. When you review 3 decades of these exact practices and you see fines that consistently reach into the billions of dollars, we really have to ask ourselves, where exactly does the cost of doing business end, and where does true corporate accountability actually begin? Thanks so much for joining me on this explainer, and remember to keep questioning what you see on the balance sheet.